2013. This is the new consolidation of statutes and statutory instruments in one edition as at 2009. This exercise started in 2009 prior to my assumption of duty. In an amendment to the Statute Law Revision Act, a new provision was introduced for the first time that recognizes the electronic age in legal publishing. It states, and I quote, "The Commissioner shall cause to be prepared and made available a read-only version of the revised edition of the laws of Seychelles," close quotes. It is not clear why it provides a read-only version, but I suppose it was the understanding of either the Attorney General or the Commissioner for Law Revision that if they had to release the electronic version, of which there must be a copy before they go to print, they had to do so in order to protect its integrity. It had to be only a read-only version. With the utmost respect, I think the legislation is misguided in this respect. If the product ever sees the light of the day, I assume there can be very little interest in a read-only version. Many of the consumers of the law would wish to have a version they can work with, copy if necessary for whatever purpose. There may be others who may be interested in adding value to the same with other works, for instance, linking it to decided decisions of the courts. This provision, more than anything, reveals either the absence of policy in this area or the attitude of key government officials concerned with publication of the law. Prior to the legislation, it was known that the Attorney General's Chambers had a 1991 edition of the laws of Seychelles in soft copy. Secondly, all legislation that had been prepared thereafter was prepared on a computer, including final versions assented to by the President. No official acknowledgement is made of this situation. Likewise, at publication stage, the process uses an electronic copy in typesetting. And so there are versions of electronic copies available that could easily have been made available. The Attorney General's Chambers, which is the official publisher of the laws of Seychelles, has no website up to date. All this is perhaps illustrative of government policy or the absence of an effective government policy with regard to access to the law in a modern environment. Against this background, it may therefore not be surprising that at this point in time, the official publisher of the Seychelles laws hopes that he will not be obliged to make available, he will be obliged to make available only a read-only version. My experience elsewhere suggests that opposition to publication of electronic copies stems from the mistaken belief that if they do so, they will not be able to sell hard copy versions which they have produced at great expense. They couple this with the claim that they would like to protect the integrity of the law so that it is not wrongly changed. These reasons do not hold water. Availability of electronic versions does not inhibit sales of hard copy versions of the laws generally. And in small jurisdictions, the cost of producing hard copies will always be high given the small market for that type of literature available locally. It is important that governments and intergovernment organizations that produce primary legal information as well as secondary legal information develop policies that are consistent with the Declaration on Free Access to the Law, the Declaration of 2007. There is a recent one which I've not been able to get a copy of as yet, which states in part, and I quote, "Public legal information from all countries and international institutions is part of the common heritage of humanity. Maximizing access to this information promotes justice and rule of law. Public legal information is digital common property and should be accessible to all on a non-profit basis and free of charge." Organizations such as legal information institutes that have the right to publish public legal information and government bodies that create or control that information should provide access to it so that it can be published by other parties, close quotes. It has also been noted that enabling public access to court-related information is associated with numerous benefits for the integrity and efficiency of the justice system. Publication of judgments allows the public, press, civil society, organizations, lawyers, judges, and legal scholars to scrutinize the actions of judges. Submitting judgments to public scrutiny through publication also regularizes the application of the law and makes judicial decisions more predictable and consistent, thus improving the quality of justice. It is therefore important that governments are encouraged to develop a policy that allows free and open dissemination of primary legal information, as this serves the public interest. At the Seychelles Legal Information Institute, we decided to publish the available 1991 edition on our website. We are also updating with other statutes and statutory instruments up to June 2012 by awarding a contract to a former legislative draftsperson and now practicing attorney to update our electronic version up to June 2012. We shall in-house scan the remaining legislation and upload it in order to get up to date with regard to legislation. For case law, we have started with the latest decisions available and intend to work our way backward to bring into the online database as many decisions as possible. From 20 decisions we found online, we now have a total of slightly under 1,000 decisions of the Court of Appeal, Constitutional Court, and Supreme Court available online. The Editorial Board of the Seychelles Law Reports has authorized me to publish the Seychelles Law Reports on CELI, and we shall be doing so shortly. This includes copies, old copies, and the new editions coming out as of now. Challenges. The fact that CELI is based in the judiciary of Seychelles would suggest that collecting judgments would be one of its least problems. No, that is not true. But it has improved tremendously. We are rather a small jurisdiction. Nevertheless, it requires a dedicated staff to do this and continuous reminders to the judges to provide the electronic copies of their decisions. As noted above, the greater challenge has been to obtain electronic copies of legislation that are known to exist with the Attorney General's chambers. In spite of the President's office, in which the office of the Attorney General is based, being supportive of CELI, this was not forthcoming. However, with the financial support of AfricanLII and its funders, we are about to overcome this situation, as I've indicated above. We have contracted somebody to produce a consolidated version up to date. Through the use of part-time staff, we plan to scan both the newer legislation and the older court decisions and continue to bring them online. We have one coordinator, Mrs. Thelma Zili, who is the head of our library services at the Supreme Court of Seychelles. It would be helpful if we were able to recruit a full-time staff, for instance, a law reporter who would work full-time on content creation for CELI. Opportunities. It is clear that online publishing of primary legal information is the cheapest option in ensuring access to the law to the largest number of consumers and users of the law. It provides a quick start to many jurisdictions that had fallen behind with the publication and consolidation of statutes, law reports, and other secondary legal materials like Law Reform Commission reports, reports from judicial inquiries, and a growing body of supranational and regional law that applies on the continent. I was talking to one layperson who revealed his joy at finding Seychelles court's decisions online. He had become a regular visitor. As a business person, his interest was tracking reliability of people he may deal with in the business world. I realized then that the audience is quite diverse, with equally diverse interests and diverse application of information available. It is not only lawyers and judges or legal scholars and their students that have an interest in this information. The audience is much wider than we may have imagined initially. We now see in courts citations of cases that attorneys have printed off CELI, an indication that CELI is meeting our initial expectation of providing a research tool to the legal profession in Seychelles. Applicable laws in a jurisdiction are often not only national laws, but also supranational and regional laws in the form of international treaties and decisions of related judicial bodies. The African Union with the African Commission and the African Court of Human Rights easily come to mind, as does SADC and the SADC Tribunal. There is COMESA and the COMESA Court of Justice, the East African Community and the East African Court of Justice, to mention only a few. The only reliable access to their statutes, legal instruments, or other binding documents and decisions of the judicial tribunals is by way of online access. Many of these institutions have websites on which these are published. However, there is very little value addition in the way the information is provided. Helpful as it is now, I see a role for AfricanLII developing a supranational and regional portal that is well indexed, text searchable, with head notes provided for decisions, the contents of which could be hyperlinked to exact provisions of the instruments that they are interpreting. Nationalists could then link onto this portal. This will strengthen national understanding of supranational and regional law and their persuasive value in national decision-making. It would highlight, too, the opportunities available for individuals enforcing their rights beyond national boundaries. The way forward, post-Johannesburg. In terms of policy development, it may be important that AfricanLII develops a program or an activity that targets attorneys general or all other authorities on the African continent responsible for publication of laws to get them to agree to the free access to the law principles and the duty of national agencies providing access at cost of national legislation without restriction for further value addition and or republication. I know that commonly had got the Attorneys General of the Commonwealth at one time to sign up to a similar undertaking. Such a program could bring the Attorneys General up to date with what is happening in many other jurisdictions worldwide, whereby official publication of laws online is now accepted. Continued support to and collaboration with national leads on the continent to improve quality of primary legal information available online will continue to be essential. Establish a supranational and regional law portal that national leads may link into to increase access and visibility of supranational and regional law. Lastly, much as there is no single business model for a successful national law, it is important that AfricanLII, as the midwife of many of the national laws on the continent, continues to ponder research, and collaborate with nationalities on what may prove to be successful business models that will assure sustainability of nationalities even in the absence of initial champions that helped give birth and establish the nationalities. Sustainability and growth must be at the center of all our efforts. I thank you for listening to me.
Our next speaker will be Ms. Amy Mclean. Ms. Amy Mclean is a legal officer for freedom of information and expression with the Open Society Justice Initiative. Her work focuses on freedom of information and expression internationally. Mclean worked previously as a staff attorney at the Center for Constitutional Rights on issues related to Guantanamo and other forms of executive detention, including through litigation, legislative reform, and international advocacy. She also worked for Medicine Sans Frontières, or Doctors Without Borders, as the deputy head of mission for the MSF's HIV/AIDS Care and Treatment Project in South Africa, and later as the U.S. director of the MSF Campaign for Access to Essential Medicines. Ladies and gentlemen, let's welcome Ms. Amy Mclean.
Thank you so much for that introduction. Can everyone hear me? Yes, okay, good. I got a text message from Maria saying yes, so I'm going to continue, and I hope that someone will identify if there's any problems with the technical side of this. It's really an honor and a privilege to be here, and I can't thank AfricanLII enough for inviting me, and UNDP for also joining in hosting this really important event. And for what gathered from the list that I, prior to this, although I was misfortunate not being able to be there in person, a really distinguished group of people quite committed to seeing a way forward, and that's already been evidenced by the early statements that have been made. And I should say, at the outset, that for me, they're quite early statements. It's 3 a.m. where I am in New York, so I hope you'll bear with me if I seem a little bit tired. I'm very sorry not to be able to be there in person with you all in Johannesburg. I am not a public servant like some of you, but I'm a member of the public, and our elections in the United States are tomorrow, and I felt as a member of the public it was critically important that I'm here, but I am also with you virtually and grateful for the kinds of technology that allows this, that were identified in part by Nicole Fritz's early presentation. And as a lawyer, but also as a member of the public, I can't overstate the importance of this kind of discussion and of the forward-looking steps that can come out of a conversation like the conversation that we're having today here. I was introduced as a lawyer working on freedom of information and expression issues with Open Society Justice Initiative. And just because some of you may not know what Open Society Justice Initiative is, I'll say briefly that it is part of the Open Society Foundation. And on the continent, the foundations that you're likely familiar with are OSISA with Southern Africa, Open Society Foundation of South Africa, OSIWA, which works in West Africa, and OSIA, which works in East Africa. There's a variety of nations around the world that are part of the broader Open Society Foundation's umbrella. And the Justice Initiative, where I work, works on strategic and law reform in partnership with organizations around the world. So really, it's a pleasure to be here. And I think I have slides which I think Maria perhaps is running through, so I hope we'll be more or less in tune. My talk will be hopefully more or less with the I'm going to speak about right to information as something of a foundation to build on the broader conversation of right to information, right to judicial information, or right to legal information. So I'm going to speak slip to the overview slide. I'm going to speak briefly about what the key principles are on right to information that come from international and comparative law. And why right to information matters. Some of the reasons have already been referenced. Is there a problem?
Yes, we are just going to open the slides now. I'm sorry.
Oh, no problem. You haven't said anything yet.
Okay, so
And
there you go.
And I hope someone will identify if I'm either speaking too quickly or not clearly enough, or if there are technical problems.
Okay, we are ready.
Okay, great. Thanks so much, Maria. So, and then I'm going to speak a little bit about right to information law and practice in Africa, and proactive disclosure and the relevance of proactive disclosure for access to legal information. We'll talk about shortly. There's been an enormous growth of the acceptance of access to information as a fundamental right over the last 20 years. In the early 1990s, there were only around a dozen countries that had